Guys, the judges of the Supreme Court of Justice.
Good afternoon to all who have joined us. It's a pleasure to see so many faces. And we trust that among the Mooters, among our students, there are even more smiling faces. It's finished. You've done your best. So we come to a most interesting aspect of the Moot, which is the comments of the judges on the performance of each session. And I call first my sister, and that sounds good, my sister, Justice Ononowu, to handle the first session.
Thank you, Chair. I'd just like to start with respect to our first mooting session between the Norman Manley Law School and the UWI Mona Law Faculty to first have us formally acknowledge and commend the advocates. So I'm going to first ask just to stand from the Norman Manley Law School, Ms. Kadeen Brown, the first advocate, Mr. Ravi Davis, please keep standing, the second advocate, and the reserve, Ms. Amoya Lin, yes, and from the University of the West Indies Mona faculty, the advocates, Ms. Antonisha Henry, Mr. Simon Lamb, and Ms. Tarani Hunt. And I would just invite everyone to please give them a warm round of applause. And I'm just going to provide some very general feedback before announcing the outcome of that particular moot. First, both teams really demonstrated pretty good appreciation of the issues raised by the moot problem. And generally, both sides in their written submissions and in their oral submissions cited and adduced relevant authorities. We found, particularly with the Norman Manley Law School, we were struck that there were useful references to the preamble of the revised treaty. Also what was also notable was the way in which the factual matrix was harnessed in some respect. Where authorities are concerned, though, we just want to reiterate that when the court sits in its original jurisdiction, it's sitting as an international court. It is bound by Article 217 of the revised treaty to apply rules of international law which are applicable. And so in that capacity, when you're appearing as counsel, be very careful with how you cite authorities like cases of domestic courts, because they're not going to have the same persuasiveness as when the court is sitting as an apex court. We also would just want to say generally that as an advocate, it's important when you're constructing your arguments to see how you can best harness and marshal the relevant facts from the moot problem or from your case. And certainly avoid introducing facts that aren't evident from the record, okay? And in terms of legal arguments, we found some quite creative. The argumentation relating to the community agreement, for instance, and how the protection of the rights of Indigenous persons was something that was necessary from the production sharing agreement. The way in which teams dealt with the issue of whether the rights of community nationals had been impaired. We also want to just stress that as an advocate, think carefully about whether certain arguments you're making are actually advancing your case, if they're helpful to your case or not. And if the other side hasn't raised an argument, carefully consider if it's constructive for you to advance that argument for yourself. We just want to commend both sides as well in the efforts that they made to anticipate and rebut the arguments that were made by the other side. And we want to highlight as well, just to give some specific comments to UWI Mona as well, that we found the oral submissions to be very well structured, in terms of how the arguments were set out. We acknowledge that in some cases your strategy was to just admit upfront there were certain limitations to the case, but to nonetheless advance credible arguments. And again, we found the responsiveness to the questions that were posed quite good, because of course, an important part of being an advocate is thinking on your feet. And so we really commend counsel on both sides for their efforts in that regard. Having said that, I'm pleased to announce that the winner of this particular mooting session is the UWI Mona Law faculty. Also pleased to announce that of the 2 written submissions, we found the written submission from the Norman Manley Law School to be better. So the Norman Manley Law School would have been awarded that. And the panel found that the best oralist from this session was Miss Antonisha Henry from the UWI Mona Law faculty.
Thank you, Justice Onono. And I considered, and we considered the second mooting session. The students who represented the Anthem de Com University of Suriname. When I call your name, you can stand. The first advocate was Miss Gabrielle Welson. The second advocate, Miss Keisha Santos. And the reserve, Miss Anoshka Gajada. And from the University of the West Indies, KFIL, first advocate, Miss Deborah Bryan. Second advocate, Miss Alala Moore. And the reserve, Mr. Kyle Harrison. Let's give them a round of applause. You miss it. Thank you. I am pleased to say that these teams were generally well prepared and engaged us on some interesting arguments. We had hoped that Anton de Com would have had a better appreciation of the facts and the law, and that they would have conducted a more complete analysis of the problem posed by the moot. We were also hoping that the authorities referred to, and Justice Ononaru mentioned, that would have been taken from international law and not from domestic courts. But we were happy to see that Anton de Com worked well as a team. You displayed proper court etiquette, and that both advocates stayed within their allotted time. So we were happy for that. As to UWI KFIL, this was an extremely well-prepared team that displayed a high level of confidence, employing well-structured arguments. The context of both your written and oral submissions revealed an insightful assessment of the problem posed by the moot. And you had a very good grasp of international law principles and of community law. We were also impressed by some skillful advocacy by UWI KFIL, especially on the points of state practice and attribution. We were also pleased with how you were quick to answer some very difficult questions that were posed to you. And so, because we are constrained by time today, let me go on to make the well-deserved announcement. As to the winner of this session, UWI KFIL. The best oralist is Miss Alala Moore, and you can stand, ma'am. And of the 2 written submissions, we say that the better submission was made by UWI KFIL.
that sort of summed up what happened on day one. And by the time we reached day two, I think everybody was a little more settled. And as I explain a little bit about our reflections on session one, I think that'll become apparent. But first, let's ask the mooters for session one on day two from the Eugene DePuche Law School. First advocate, Shanette Brown. Second advocate, Ronique Brown. And the reserve, Theon Coggins. And then from the University of the West Indies, St. Augustine, first advocate, Alexia Trim. Alexia, yes. Second advocate, Sage Mitchell. And the reserve is Miriam Salamat. And can we please give them Thank you very much. I think on day two, which is today, we decided to ask harder questions. And these two teams in session one this morning were interrogated with very difficult questions that were probing and put them on the spot in many ways. But both teams handled themselves exceptionally well. They demonstrated, first of all, in their written preparations, both teams, excellent preparation, good relevance to issues and use of authorities and analysis. Advocacy, they say, often separates winners from losers, and that's what mooting is about. And what we thought is that, and this is true for both teams, you were structured in your approaches, but sometimes if you were to assert a principle, you must remind yourselves to cite a relevant authority. That's a small area of deficit when you review your own written submissions. I think some of you will pick up where you made very pointed statements, but did not necessarily support that with an authority, and that's important. The argumentation in the actual mooting was excellent. It was creative and relevant, and both teams demonstrated an excellent use of context and facts. One of the things that stood out for us, and to this we give credit to the University of the West Indies, was innovative and creative but relevant use of facts. And so, for example, they were the only team to recognize that in 2019, the COVID-19 pandemic was a relevant issue that could impact the economic state of small island territory. And they included that in their justifications, etc. We thought that is this sort of creative but relevant preparation and advocacy. Also, at the very end, again, the University of the West Indies, St. Augustine made a point, which was, if this matter was before the heads of government and a working group had been set up to look into it, should this court be adjudicating? Or should this court allow the community to decide what should be done? Again, it demonstrated an innovative and creative approach to a situation and properly presented in a court called to adjudicate on issues. So in terms of context, content, strategy, and advocacy, as I said, both of these teams demonstrated exceptionally high levels of skill, preparation, and competence. But as in all things, we have to choose. I must say, between these two teams, it was very, very close and hard fought. Our overall winner, nevertheless, is the University of the West Indies, St. Augustine. The best written submissions, as they say, by a hair's breadth, went to the Eugene DePuche Law School. To choose between the best oralist is always difficult when you have so many good oralists, and that was true in this session. But nevertheless, we have selected Alexia Trim. So thank you all.
Thank you, Judge.
Now we move to the final mooting session that we had earlier. This was between the Hugh Wooding Law School and the University of Guyana. And again, I'm going to ask, representing the Hugh Wooding Law School, First Advocate, Mr. Eden Corbin. Second Advocate, Ms. Marquita Belgrove, and the Reserve, Ms. Soraya Singh. From the University of Guyana, First Advocate, Mr. John Applewhite Hercules. Second Advocate, Mr. Fabian Green, and Reserve, Ms. Thomasa August. If we could please give them a round of applause. Please be seated. I just want to start by acknowledging that both teams really brought passion to the way in which they advanced their case. They both had developed a strategy for presenting their case, and they certainly adhered to it. And we observed that overall, you know, they demonstrated and displayed proper court etiquette as well as good teamwork. But here I want to just follow on from some of the points made by Justice Jamadar about the importance of preparation to advocacy. And I'm going to reiterate again the point made earlier about the importance of citing applicable rules of international law when the court sits in its original jurisdiction. Also stressing the importance of understanding the rules of procedure of the court. For instance, the distinction between private parties needing to seek special leave of the court in order to bring proceedings, whereas a member state of CARICOM having the right, without seeking special leave of the court, to bring an originating application. But returning to the point about the importance of preparation, we found both teams could have done with a bit more preparation of their case. Why is preparation important to advocacy? It impacts how it has a very direct bearing on the content of what you argue. It has a very direct bearing on the strategy you deploy in advancing your case. So it impacts how you construct your case. It also influences the readiness, your readiness and the confidence with which you are able to think on your feet and you're able to respond to questions from the bench. And you must be prepared to deal with questions from the bench. And when questions come from the bench, they often are trying to keep you focused on the key issues that you really need to address, particularly in a context where you have limited time, to ensure that before your time runs out, you hit the most important points that you have to in order to make your case. And so in terms of strategy, you also need to reflect very carefully on the relative strengths and weaknesses of what you decide to make a focal point of your case. So if you are going to, for instance, make on this moot problem, Article 30 a central point, you have to reflect carefully whether, based on the facts, that is really the strongest argument you want to make the centerpiece of your case. Preparation also requires you to think carefully about what points you may want to concede upfront. So even if you may not devote as much time to arguing certain points, do you want to concede them outright? Having said that, we do want to commend the fact that we saw that there was some thought given ahead of time to how much am I really going to devote to arguing certain points relative to others. And the last point I would just want to make is the importance of being very precise in your submissions, because you have to keep the focus of the adjudicators on the key points you want to resonate with them. So think carefully about whether you want to spend a lot of time on introductory points or whether you want to be very precise and focused, including in a reply where you have to really be targeted at the weaknesses in your opponent's case. So with those general comments having been made, we're pleased to announce that the winner of this mooting session is the Hugh Wooding Law School. Of the two written submissions, we found the written submission of the Hugh Wooding Law School to be better. And of the oralists from this session, I would like to ask this particular advocate to stand. We found Miss Marquita Belgrove to be the best.
Thank you, colleagues. And it gives me great pleasure in closing this aspect of the moot before we go to the closing ceremony to make some very brief remarks. I wished first all to give these mooting teams a round of applause. I wish to begin by congratulating you on a job well done. These 2 days have been stimulating and enjoyable. We have all learned a lot, and yes, that includes us, the judges. You always bring fresh perspectives, and you look at issues in ways that we may not have considered before. Furthermore, we were pleased to observe that the teams were generally well prepared and acquitted themselves well. And so on behalf of Justices Jambada and Anonawu, I say to you once more, well done. We wish as well to place on record that this is a very special moot. As you are aware, the Caribbean Court of Justice is celebrating its 20th anniversary. We are also pleased to highlight that the CCJ International Law Moot celebrates its 15th anniversary. The CCJ held its first moot in March 2009. And apart from the years 2020 and 2021, the COVID years, has hosted its annual International Law Moot every year since. As to the issues argued by the teams, we do not propose to deliver judgment, since we are aware that matters based on similar facts may come to the court. We will therefore make some very brief comments on the issue as time permits. But before we do that, we wanted to make some preliminary remarks. It is with a sense of sadness that we bid farewell to Justice Burgess, the chair of the CCJ International Law Moot Committee, and he has been chair over the past 6 years. Justice Burgess leaves us to spend more time with his beautiful and talented wife, Sandra, his 2 sons, and his family. Justice Burgess, on behalf of all present today, I wish to convey our sincere gratitude for the valuable contribution you have made as chair of the Moot Committee and as a judge of the CCJ, and to wish you God's blessings. Let's give him a round of applause. This is an appropriate stage to note that at the 2024 Moot, we decided that we would ask the teams to pay more attention to their written submissions. As you are aware, 2024 was the first year that we awarded the Justice Jacob Witt Prize for the best written submissions. In his closing remarks, in what was his last moot in 2023, Justice Witt opened with these words: "Brevity is the soul of wit." Justice Witt disliked long and drawn-out written or oral submissions or even judgments. Brevity was indeed his hallmark. We wish to record once more our deep appreciation for Justice Witt's dedication and service to the CCJ International Law Moot. Last year as well, we highlighted the usefulness of teams setting out an opening statement in their written submissions. Such a statement would cause the teams to focus on the crucial issues arising out of the brief. We are pleased that some have heeded that advice. Additionally, we observed that many teams began their oral submissions with well-crafted opening statements. And the teams addressed several issues, and we won't go through all of them in detail, merely to mention them and to say a few brief remarks on each. The first issue really was whether the Republic of Gaitrin had breached the revised Treaty of Chaguaramas, and we divided this more or less into two parts. One, can the acts disclosed in the fact pattern be challenged as acts of the Republic of Gaitrin? And this was a question that Justice Honoru pursued a lot with many of you. And we do not propose to repeat, though, all the interesting arguments that we heard on the issues of state practice and attribution. We know that Antigua and Barbuda bore the burden of proving that Gaitrin breached the revised treaty. The second question really was about, has Gaitrin breached Articles 7, 32, 36, and 46 of the revised treaty? We heard again compelling arguments on the principles applicable to those articles, whether they were breached by the actions or by the policy of Gaitrin. And may I say that we were attracted to the less attractive argument as well. There were also some novel submissions on the community agreement and the issue of training and capacity development of Gaitrinians by Hex Mobile. Happily as well, most, if not all of you, grasped that Article 7 was not a standalone provision and that it did not confer an inherent substantive right. And we've really made progress in that area just between last year and this year. The second issue, and I think this was a more difficult issue, whether these restrictions can be justified under Articles 43 and 47. And as the party invoking the exception, Gaitrin bore the burden establishing that any restrictions on these Chapter 3 rights can be justified under Articles 43 and or Article 47. And there was no jurisprudence of the CCJ on this issue. Therefore, you were expected to examine these provisions in detail. We were disappointed that some of you didn't do that. They sort of read it so quickly, but you didn't understand the various ingredients in the provisions. Then you were expected to look at the jurisprudence of other international courts, but this jurisprudence had to be relevant, not just to cite a case because you want to put a case into the written submissions. And then you could look at other texts on international and community law. We were impressed by the arguments as to the impact of the failure to comply with the procedural and substantive requirements of these articles. We appreciated those teams that examined Articles 43 and 47 in the context of the revised treaty as a whole, and submitted that in line with the jurisprudence of the CCJ, the court ought to employ an approach to the interpretation of the revised treaty that focuses on its purpose and its objectives. And we were happy that many of you were comfortable with Myrie, with TCL, with Tomlinson, with Ellis Richards. We were very, very impressed. But in closing, because time is going, we wish to make two further comments, and the comment has been made before by both Justice Jamada and Justice Honoru, which is that we observed that there was, in some cases, an unfortunate acceptance that the facts supported your case without any proper analysis of the fact pattern. This is an area of your advocacy that needs attention. It is said that facts are stubborn things. You can't get rid of them. You have to deal with them in the court. And therefore, we wish to encourage you to have a proper command of the facts and, of course, the law when you go into court, when you become an attorney. We trust that this advice will prove beneficial to you in your future endeavors as an advocate. We also note that although the fact pattern at first glance appeared to favor the teams appearing for Antigua and Barbuda, we were happy to observe that the teams appearing for Gaitrin made the most of what was served up to you. And on behalf of my colleagues, we express our sincere appreciation to the staff of the CCJ, and in particular, Ms. Jasmine Sargent and Mr. Jacob Phillips, our judicial counsel. Please stand. These young people greatly assisted the judges in this moot. Thank you very much. You may sit. And of course, to the students here before you doing the work of the registry staff. Well done. Congratulations to all. Thank you very much. Madam Registrar, over to you.
Thank you, Madam President. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Onanaru. This court now stands adjourned. Good day to all.
You just come down. Come down. You just
Thank you. You may be seated. The Honorable Mr. Justice Adrian Saunders, President of the Caribbean Court of Justice, judges of the Caribbean Court of Justice, distinguished members of the Diplomatic Corps, chairs of commissions and superior courts of record, honorary consuls, CARICOM officials, members of academia, members of the legal fraternity, law moot teams, staff of the Caribbean Court of Justice, members of the media, ladies and gentlemen, good afternoon. Welcome to the closing ceremony of this our flagship event, the 15th annual CCJ International Law Moot. The Caribbean Court of Justice celebrates its 20th anniversary next month, and this event has been the longest standing activity in its history, dating back annually from 2009. Save and except for those COVID years that we wish to banish from our memories. As we bring the curtains down on what has been a riveting 2 days of competition, we pay tribute to 24 students hailing from 8 schools in the Bahamas, Barbados, Guyana, Jamaica, Suriname, and Trinidad and Tobago. They showcased their in-depth knowledge and understanding of the principles of the revised Treaty of Chaguaramas. And as we can imagine, that is not for the weak. Under the keen eyes and ears of the Honorable Justices Rajnath Lee, Jamada, and Onanawu, students had to demonstrate their dexterity, orate to the best of their ability, and pontificate their points with precision. After the insightful remarks from the Moot panel, we are certainly ready to hear the results of the competition. But not before we listen to the remarks from the chair of the CCJ Law Moot Planning Committee, the judge who has brought this year's competition into fruition, an educator himself who once stood as a student, with students, and for students. We welcome to the podium now the Honorable Mr. Justice Andrew Bridges.
Madam Master of Ceremony, protocol having been just so perfectly established by your good self, I beg to adopt it and to thank you for your very kind. This evening, as you've heard, I address you in the capacity This evening, I address you in the capacity of Chairman of the CCJ Law Moot Committee. In this regard, it is for me an honor and an undiluted pleasure to extend warmest welcome to this closing ceremony of the 15th Annual CCJ International Law Moot Competition. Since its inauguration in 2009, this moot competition has been a marquee event in the calendar of regional law schools and law faculties. We at the CCJ are aware of the importance of the competition in contributing a Caribbean perspective on law to you, our up and coming lawyers. Accordingly, the objective of the moot has always been to provide an opportunity to educate and foster greater interest on the working of the revised Treaty of Chaguaramas and the development of its jurisprudence in the CCJ's original jurisdiction. In hosting this moot, we wish to demonstrate our investment in you, the future attorneys of the region. The issues raised in the moot competition are issues which have arisen or which may arise in one fashion or another during your career. And who knows, you may appear before this court in the future litigating these matters and other issues. Now, the moot problem is the foundation of the moot competition. It provides mooters with the facts, legal issues, and grounds for argument. This year, it was particularly challenging in my view, and it was fair. It was carefully designed to be arguable on both sides. It required you to carefully analyze the facts, research the law, and present persuasive arguments. I must confess that I was totally impressed by the enthusiasm and dedication demonstrated by the moot teams over the last 2 days, and by the extremely high caliber of your arguments presented before the judges. President, the judges being president and presiding judge, Madam Justice Rajnath, Mr. Justice Jamadar, and Madam Justice Anano. And let us admit it, during your oral presentations, our crafty judges raised some very tricky questions with you. In my respectful view, you dealt with these questions with admirable adroitness. When you knew the answers, your responses were absolutely brilliant. When you did not know the answer, you sidestepped deftly the questions. But the parrying between the wily bench and you, the young mooters, was thoroughly enjoyed by us, the audience. may I bestow my sincerest congratulations to all this year's Mooters. You did yourselves and your institutions proud. As a former teacher of law in the University of the West Indies faculty for over 35 years, I have witnessed the strengths that can be developed and the weaknesses that are discovered by students through a mooting competition. The entire experience, from preparation of arguments to standing before the moot court, making these arguments, improves a participant's overall understanding and knowledge of the area of law. Students gain invaluable experience and training in written and oral advocacy, coupled with the honing of legal research, analytical and reasoning skills. This knowledge and these skills are and will be extremely valuable and eventually considered as advantageous by your future employers or by yourselves should you choose to practice on your own. Simply put, the Moot experience will be, no doubt, remembered by you as a defining landmark in your development as attorneys and jurists. Before I close, I would like to personally thank my sisters and brother on the Moot bench, the President and Presiding Judge, Madam Justice Ratnath Lee, and Mr. Justice Jamadar and Madam Justice Onanu for dedicating their time and energy to this year's competition. We truly appreciate their skillful use of the Socratic method in making this moot extremely interesting. Could we raise a round of applause for our moot judge? As chair of the Law Moot Committee, I also wish to extend my deep appreciation to the members of the Moot Steering Committee, the subcommittees, and all those who worked tirelessly and dedicated themselves, their time and energy to the staging of the competition. They also deserve a round of applause. A very special thank you also to each and every one of the Moot teams, the students and the advisors for participating in the Moot competition and contributing to its resounding success. For those of you who travel from other Caribbean territories to participate, I hope you've enjoyed your short stay here in Trinidad and Tobago. A round of applause for the Moot team. Finally, I must extend my sincerest anticipatory congratulations to this year's champion team, whichever it may be, on your victory over the other teams to win the coveted CCJ Shield. I wish also to extend anticipatory congratulations to the winners of the Sir Henry Ford Best Oralist Prize and the Mr. Justice Jacob Witt Best Written Submission Prize. In closing, I wish to share with you that I retire. Well, it's no longer a secret because it was disclosed earlier from the bench. I wish to share with you that I retire from being a justice of this court on the 11th of April this year. The last 6 years, I've had the distinct honor and privilege of serving as chairman of the Moot Committee. This address this evening is therefore my swan song. In it, I would like to acknowledge with gratitude all those who have made my tenure as chairman such a memorable experience. I thank you all.
Thank you, Mr. Justice Burgess. The CCJ Registry likens itself to an engine room. I'm not certain if they have a deep affinity to Calypso King David Runner or Soca Master Olatunji, but I suspect that they are correct in their presumption. You see, the registry is where the core work of the court is mastered and delivered, as it plays a critical role in managing all matters from filing to disposition and providing the necessary support for the bench and the disputing parties. This year, the registry unit oversaw a group of 10 students from the Faculty of Law at the University of the West Indies, St. Augustine, to fit them for this very purpose. So we wish to recognize each of them and present them with a certificate of appreciation for their dedication and contribution to the success of this year's Law Moot. So I will ask Mr. Anil Ramsahai, Registry Supervisor of the CCJ, whose guidance was pivotal throughout the orientation and training of the students, to help present the certificates. I'm calling in alphabetical order Miss Annalicia Edmond. Ariana Ramhit. Alicia Perez. Daniel McMillan. Delonte Lewis. Krista Douglas. Joshua Chotai. Juliana Mahabir. Felicia Neptune. And Lakshmi Maharaj Sukraj. Thank you to the Moot Registry. 8 teams went head-to-head for the prizes this year. So who is going to emerge victorious? I want to encourage all of the institutions. You were brave and diligent and represented your schools well. We are very proud of each of you because not every lawyer can stand before the highest court in the region, but you did that. So now, ladies and gentlemen, we will award the recipients of the bronze medals. So I invite Mrs. Ria Mohammed Pollard, the CCJ's Communication and Information Manager, to help with the presentation of the prizes. So congratulations to the students from the Anton de Kom University of Suriname. Sorry, one moment, please. Yes, yes, Anton de Kom University of Suriname. That's Gabrielle Welzen, Keisha Sankis, Anushka Gajada. Keisha Sankis. Anushka Gajada. Also receiving bronze medals are the students from the Eugene Depuch Law School. Shanette Vanessa Brown, Ronique Terrell Brown, and Tion Timothy Coggins. Shanette Brown, Ronique Brown, Tion Coggins. Bronze medals also go to the Hugh Wooden Law School. Eden Corbin, Suraya Singh, and Marquita Belgrove. Eden Corbin, Suraya Singh, and Marquita Belgrove. We also wish to present bronze medals to the Norman Manley Law School. Kaylin Brown, Ravi Davis, and Amoya Lynn. Kaylin Brown, Ravi Davis, and Amoya Lynn. Winners of bronze medals are also from the University of Guyana. John Appleworth, Hercules, Fabian Green, and Thomas August. John Applewhite Hercules. Fabian Green. Thomas August. And rounding out this category of bronze medalists, we have the University of the West Indies, Mona campus. Antonisha Henry, Simon Lamb, and Therani Hunt. Antonisha Henry, Simon Lamb, and Therani Hunt. Thank you, Mrs. Mohammed Pollard. So as we proceed where the air is getting rare, the silver medals are for the team that placed second overall. So I'd like to invite CCJ Senior Manager Corporate Administration, Mr. Shivanan Ramnanan, to come forward to help us with the presentation of prizes. Thank you. So our second place winner is the University of the West Indies, St. Augustine campus. Alexia Trim, Sage Mitchell, and Mariam Salamat. Alexia Trim. Sage Mitchell. And Mariam Salamat. The Henry Ford Best Oralist Prize was introduced in 2023 to recognize the student the judges consider the embodiment of the role. This person is recognized for his or her oratory and advocacy skills during the competition. And this is really the time when the teachers remark in the report card that says, talks too much in class. It finally pays dividends. Thank you very much to the benefactor for making this prize possible. I therefore am very pleased to announce that the winner of the 2025 overall Sir Henry Ford Best Oralist Prize of US 250 Amazon gift card is. But before we announce, I'd like to invite Madam Justice Ononowu to come help with the presentation. So now I can see the winner of the 2025 Sir Henry Ford Best Oralist Prize is Miss Alexia Trim. Congratulations, Ms. Trim, and thank you, Justice Ononowu. In 2024, unfortunately, we lost a member of our inaugural bench, a judge well known both for his wit and economy of words. And in tribute to the late Mr. Justice Jacob Witt, another kind benefactor donated a prize. And so we would like to ask Mr. Justice Peter Jamada to help us with the presentation of this prize. Thank you, Justice Jamada. And I would like to announce the winner of the Justice Jacob Witt Best Written Submission Prize as the Eugene Dupuche Law School. So we'd like to invite the whole team, Ms. Shannon Brown, Ronique Brown, and T.M. Coggins to come to collect your prize. The advisor was Mr. John Mins. Well done, Eugene Dupuche Law School. And thank you, Justice Jamada. For the next prize, I'd like to invite the chair of the CCJ Law Moot Planning Committee to come help us make this presentation, Mr. Justice Andrew Burgess. Now, this prize is the best academic institution, and it's awarded to the academic institution which is not a law school, but which, in the judge's opinion, was a 10 out of 10, performing exceptionally well. And in 2025, the winner of this prize is the University of the West Indies, Cave Hill campus. Deborah Bryan, Alala Moore, Kyle Harrison, receiving the plaque for the best academic institution. Congratulations. Thank you, Justice Burgess. I would like to ask our Honorable President, Mr. Justice Adrian Saunders, to come help us with this final presentation. We're now going to crown the team that was creme de la creme. And I'm going to let them get some steps in today, because I'm pleased to announce that the overall winner of the CCJ Annual 15th International Law Moot of the Challenge Shield is awarded to the team from the University of the West Indies, Cave Hill campus. They receive Amazon gift certificates valued at $150 each for their outstanding performance today. And they also receive books courtesy the CCJ Academy for Law. We have Deborah Bryan. Alala Moore. And Kyle Harrison. Wait, there's more. Shield. The advisor was Dr. Antonius Hippolyte. Thank you very much, President. That was exciting, wasn't it? So I'm still here. So there's more. Mr. Justice Andrew Burgess has been the presiding chair of the CCJ Law Moot Planning Committee since 2019. Earlier this week, the court marked his fast approaching retirement with a special sit-in. And we too at the Law Moot want to acknowledge him as the outgoing chair. So, personally, I salute you, sir, as the daughter of a sergeant. I wish you all the best. Thank you so very much for your tour of duty. And so I invite President Saunders to come say a few words in acknowledgement to our outgoing Law Moot chair.
Thank you very much, Dr. McCarney. All protocols observed. So, we are at the end of another successful CCJ International Law Moot. And I'd like to congratulate again all the participants, teams, and advisors on your efforts. I especially congratulate the winner of the Moot, the University of West Indies Cave Hill Law faculty. But I also wish to take this opportunity to recognize in particular our Surinamese students from the Anton de Com University and say thanks to them for their consistent efforts at this Moot competition. These students are required to think in a language that is not native to them and in a time-constrained environment to present technical legal arguments in that language. And they do so year after year, competitively matching their rhetorical skills with those of you who have the advantage of rendering your submissions in your mother tongue. So I think we owe a special debt of gratitude. This afternoon, as you've heard, also marks the end of the tenure of my dear friend and colleague, Mr. Justice Andrew Burgess, as chair of this Law Moot committee. And it is therefore fitting that I should briefly pay tribute to him and to publicly thank him for his years of dedication and service in his role as chair of that committee. Justice Burgess took over as chair in 2019 when he was appointed to the CCJ bench. He actually succeeded Mr. Justice David Hayton, who guided the Law Moot from its inception and whose organizational work contributed to its success and popularity among regional law schools and faculties of law. Justice Hayton was also an academic. He came to us from the University of London. And when he retired from the bench, Justice Burgess took over the reins and guided the evolution of the Moot into what I would consider to be a first-class co-curricular activity offered to law students to develop and test their advocacy skills. And what's very special about this Moot, as I said at the opening, is that you test those advocacy skills before the highest court in the Caribbean. And the judges of the Law Moot treat you no differently from the way in which they treat the advocates who appear before us at substantive trials. New prizes were introduced under the tenure of Mr. Justice Burgess, namely, as you have heard, the Justice Jacob Witt Prize for Best Written Submissions, and another prize, which is personal, very personal to Mr. Justice Burgess, the Sir Henry Ford Prize for the Best Oralist. Justice Burgess's term as Moot Committee Chair has not been without challenges. In his first year as chair, the 12th annual international, what would have been the 12th annual International Law Moot, had to be postponed due to the restrictions imposed by the COVID-19 pandemic. In 2021, It was also agreed that for the same reason, the competition should not take place. In 2022, the decisive action was taken not to allow COVID once again to frustrate the hosting of the Moot, and it was decided to produce a competition worthy of its predecessors, albeit in a different format. Those of you who didn't know, Justice Burgess is not only an experienced jurist, but he's also an eminent member of the academic community and an expert in company law. When he and I were trained as lawyers, we actually overlapped at Cave Hill. All our textbooks were written by Englishmen and women. Only if a Caribbean case made it to the Privy Council did it stand a chance of being cited in any of the texts we used back then in the mid-70s. Thanks to persons like Justice Burgess, Caribbean jurists now author many of the textbooks that we use at regional universities, and Justice Burgess himself has authored two. Some of you may have come across his extremely useful texts in your studies, The Law of Corporate Receivers and Receiver Managers, and also Commonwealth Caribbean Company Law. Few persons in the region have, like Justice Burgess, been in academia for over 3 decades, tutoring, mentoring, and molding law students. The CCJ greatly, therefore, benefited from that wealth of experience, and we have deployed his keen insights and his understanding of the needs of students into the organization of this Moot experience. On behalf of all of us present, Justice Burgess, we wish it to be placed on record that we do not take at all for granted the valuable contribution and leadership you have given to this competition. I thank you for your outstanding service to this very important CCJ initiative. You have further enhanced its appeal and made it an endeavor that constantly rises in quality each year. On behalf of the judges, management, and staff of the Caribbean Court of Justice, I say thank you for your dedication to the court, to the Moot, and to shaping all the young minds who participated in this competition over the years. I thank you very much.
So we would like to present Justice Burgess just with a little token from the Law Moot to say thank you. Thank you, judges. And now, as we bring the closing ceremony to a close, I now welcome the Registrar and Chief Marshal of the CCJ, Mrs. Gabrielle Figaro-Jones, to deliver closing remarks and a vote of thanks. Mrs. Figaro-Jones.
Thank you very much, Dr. McConney, an excellent job. With all protocols having been formally established by the previous speakers, I adopt these protocols and wish you all a very warm welcome. For the past 20 years, the Caribbean Court of Justice has distinguished itself as a court of excellence. We take immense pride in being the first court in the Western Hemisphere to be inducted into the International Consortium for Court Excellence, a recognition of our unwavering commitment to judicial excellence, innovation, and the rule of law. But we are more than a court that continually strives for excellence. The CCJ stands as a pillar of sovereignty and development in the Caribbean region. It is a cornerstone of our collective journey towards self-determination, ensuring that our region's legal and economic aspirations are met through a framework that reflects our unique identity, culture, and governance priorities. It is against this backdrop of the pursuit of excellence and regionalism that the CCJ hosts this competition annually. It is more than an academic exercise. It is a platform for building legal excellence and deepening the understanding of regional law. The issues debated here, rooted in the revised Treaty of Chaguaramas and in the principles of Caribbean integration, are central to the continued growth and success of our economic and legal systems. I think it is fair to say, therefore, that after seeing the quality of arguments and the intellectual rigor displayed over these last 2 days, the future of legal advocacy in our region is bright, and the dreams of the region's forefathers for regional unity and true and complete independence are in good hands. As we bring the 15th Annual Caribbean Court of Justice International Law Moot to a close, and this is the real close, I acknowledge that this moot could not have been possible without the dedication and support of many. On behalf of the CCJ, sincere gratitude is expressed to the Honorable Mr. Justice Saunders, President of the Court, and all judges of the court whose leadership and guidance continue to shape the court's legacy. To the Honorable Justice Burgess, who has steadfastly led the Moot Planning Committee since 2019 and strived every year to make the competition an even better experience than the year before. Judge, this is your last moot with us. And I know that I speak for all of us in the committee when I say that we have grown under your stewardship and you will truly be missed. To the moot bench, ably led by the Honorable Madam Justice Rajnath Lee, and comprised of also Honorable Justices Jamada and Ononiwu. Thank you for your astute assessment of and encouragement to the teams over the last 2 days. The firm leadership of Justice Rajnath Lee, who constantly reminded mooters that their allotted speaking times were almost up. The incisive questions of Justice Jamada, who guided mooters back to the issues to be determined very skillfully, and the probing inquiries of Justice Ononiwu, who gently reminded mooters that they were appearing before an international court. Lessons learned over these 2 days cannot be found in any book, students. It was an experience, and we thank the moot bench. It's an unparalleled experience. To the faculty advisors, thank you so much for your commitment to nurturing the next generation of legal minds. Your hard work and support were evident. Thank you also to each and every CCJ staff member who contributed to this moot success. Last year, I tried to name each of you and still left out persons. But please know each and every one, thank you for your tireless efforts behind the scenes to ensure that this competition was seamless and maintains its prestigious standing. March continues to be quite a month for us. I commend you all and wish you a most well-deserved and restful weekend. To our specially invited guests, your presence here today reflects the importance of this event in the broader legal and academic landscape. Thank you for your unwavering support of the court and the region's young legal talent. Finally, but certainly not least, to our mooters and Moot Registry, congratulations on your outstanding performances. Whether you go on to become advocates, academics, judges, judicial officers, or policymakers, We trust that the lessons learned over these last 2 days will guide your contributions to Caribbean law and governance. And to this, yet, well, we should applaud that. And to this year's winner of the 15th CCJ International Moot Challenge Trophy, the University of the West Indies, Cave Hill Law Faculty. Congratulations. Your efforts have certainly paid off. All that is left is now for me to invite each of you to a reception held in the level above to honor the performance and good work of our mooters. I invite you just after this to please run up and let us have a lovely evening. Thank you for your kind attention. Good afternoon, everyone.